I'm looking at their decree. It doesn't look like it. Oh, there's the exhibit. Not the best drafted, but okay. I take judicial notice of your pleading.
And Judge, it should have the pay record attached. If I may enter into evidence an updated copy of the pay record, which I've sent to everyone and labeled as State's Exhibit 1, an updated version of the pay record that was already attached to our original pleading.
Does anyone have any objection to me admitting State's Exhibit 1 into evidence?
I don't.
Oh, thank you, ma'am. Mr. Tate, do you have any objection?
No, Your Honor.
Okay. State's Exhibit 1 is admitted and you may continue.
Thank you, Judge. I'd like to call my first witness, Ms. Ricard. Ma'am, are you the mother who, in this case, who was ordered to receive child support?
Yes.
And who were you ordered to receive child support from?
Dr. Mallory K. Tate Sr.
Okay. And did Mr. Tate Sr. pay you the child support and medical support each month as ordered by the court?
No.
Okay. And because he did not, is it fair to say that he has a balance remaining that he owes you for both child support and medical support at this time?
Absolutely.
Okay. Now, State's Exhibit 1 has already been entered into evidence by the court, and you received an updated copy of that this morning. Is that correct?
Correct.
Okay. Judge, may I share my screen with that exhibit at this time?
You may do so.
Thank you. Okay. All right. Okay, Miss Ricard Tate, can you see my screen with the pay record on there? Okay. Now, as you can see, says page 1. Can you confirm that this has you and Mr. Tate's name at the top?
Yes, that's correct.
Okay. Now, this is the State's Exhibit 1 already into evidence, but I'm going to scroll down to the last page of this exhibit. Okay, so give me a moment to scroll down.
16.
Okay. Now, as you can see, do you see the left column that says April 30th, 2025?
Yes, ma'am.
Okay. Can you see the child support column here?
Yes.
Okay. Can you confirm that as of April 30th, 2025, Mr. Tate was in the arrears $95,713.34 for child support as of that date?
Yes, that's correct.
And are you joining me in asking the court to take a child support judgment against Mr. Tate for that date and that amount?
Yes, ma'am.
And are you asking the court to set a fair payout starting June 1st, 2024 towards that amount, to pay
Correct.
towards that amount?
Correct. Because he's been paying monthly, like I mentioned earlier.
Right. Okay. So, and what amount are you okay with him paying starting June 1st towards the child support arrears?
Really,
That
the
would be
max,
fair.
I mean, if the payment can stay the same, that's fine.
Okay, so is it $1,500 a month that you're wanting to go towards the child support arrears starting June
Yes.
1st, 2025?
Yes, ma'am.
All right. Now let's look over to the column entitled medical support. Do you see that on the exhibit, Ms. Ricard?
Yes, ma'am.
Okay. And if we go all the way down and go across to April 30, from April 30, do you see that he has a medical support balance as well?
Yes, ma'am.
Okay. And according to State's Exhibit 1, do you agree with me that he has a medical support as of April 30th, 2025 in the amount of $17,956.96?
I agree.
And are you joining me in asking the court to take a medical support judgment against Mr. Tate for that amount and that date?
Yes, ma'am.
Okay. And are you okay with are you asking the court to have him pay, I think it was $125 per month?
Yes, ma'am.
And that payment would also begin June 1st, 2025. Is that correct?
Correct.
And then you are aware that any interest that may accrue, that will be, he will be responsible for any of that as well.
Yes, ma'am.
Now the kids, the twins, they've already emancipated. Is that right?
Correct.
Okay. And so the only thing remaining are these two balances. Is that right?
Correct.
Okay.
Correct.
All right. If I may stop sharing my screen at this time, Judge?
You may do so.
Thank you. Okay. All right, Ms. Ricard, now we've talked about the child support arrears and a recommended payout. Now you understand the judge decides the payout, but you've given your recommendation as well as for medical arrears and recommendation for payout. And that is what you're asking for. Is that right?
Correct.
Okay. Now, court costs, if billed by Galveston County, you understand and agree that they would be billed to Mr. Tate due a year from today. Is that correct?
Correct.
Okay. And you believe this order, if the judge agrees to these payouts in an order, that would be in the best interest of your children?
Absolutely. Yes, ma'am. Correct.
I pass this witness, Judge, at this time.
Okay, you may call your next witness.
Your Honor?
I will call Mr. Tate.
Okay. Good morning, Your Honor.
Morning.
Mr. Tate, I haven't asked any questions yet.
Okay.
Mr. Tate, did you also see a copy of the pay record that I emailed to you this morning, an updated copy of it?
Yes,
Actually,
ma'am.
okay. And did you see the child support arrears that were listed on the pay record?
Yes, ma'am. And I've stated I would not like to talk to you about.
Objection, non-responsive after, yes,
Sir,
ma'am.
I it said at the beginning of the hearing, we take testimony where she asks you questions. You can't come to court and
Excellent.
refuse to answer questions as per testimony. So if you can just please answer the questions, and then you will be given a chance to speak as well. But she knows what I'm generally looking for to get the testimony out, and then you'll get a chance to speak as well. So if you can please answer the legal questions being asked, I'd appreciate it. The factual questions being asked.
Now,
Yep.
Mr. Tate, we are here, this is the third setting on this motion to confirm arrears. Were you aware of that?
No, I was not aware.
It's okay. Did you also see them? It's okay if you weren't, that's okay. Did you also see the medical support arrears that were listed on the pay record?
Yes, ma'am.
Okay, now let's go back to the child support arrears, $95,713.34. How much per month do you think you can afford, are you currently paying right now?
It's taking out my check, $1,600.
Would it be $16.25?
$16.27.76.
Okay, thank you, sir.
Right, what number was
And-
that? 16.
$16.27.76.
I'm sorry, 1627.67.
16.27.76.
76. Okay, so that's what you're offering to pay?
Yeah.
Okay, that's very precise.
Okay, thank you. Yes, it is. Thank you, Mr. Tate. Now, you heard Ms. Ricard's testimony that she was requesting the judge to set at least a minimum of $1,500 towards her child support arrears plus $125 for the medical arrears, which would be right in line, almost $2 shy, $2.76 to be exact, shy of what you're already paying. So you're okay with that payout?
No, ma'am.
Okay, so what amount would you like to pay towards your child support arrears then?
I paid enough. I mean, I paid enough. I asked for an attorney, and what I'm stating is that the arrears are based off a forged document.
Objection, non-responsive to my question.
I think his answer was zero. He wants to pay zero.
Yeah.
Oh, he did say zero,
So,
yes.
if you can just listen to the question and answer the question.
Okay, my next question, thank you, Judge. My next question is, well, how much do you want to pay towards the medical support arrears?
$0.
Okay, I pass this witness. Judge, I have no further questions.
Okay, so as I said, both of you are going to get a chance to tell me your sides. The state doesn't represent either of you. I'm going to start with Mr. Tate. Is there anything additional you think I need to hear?
No. Okay. Good morning, Your Honor. I'm a non-custodial parent. I respectfully request a temporary pause or enforcement actions, including child support arrears and passport restrictions, until I can fully be recognized by legal counsel. I recently discovered significant issues regarding documentation that I did not authorize or sign, and I have begun to gather a lot of information about it. To address these concerns. At this time, I'm not prepared to proceed without an attorney, and I respectfully ask that the court grant a brief continuance that my legal representation can help me gather more information. If you need more information, I can tell you.
I do, sir, because this case has been on file since July. The last setting I see was reset back in February, so that's 3 months ago, to today, and it was specifically reset, it looks like, for trial on the merits and to allow time for your attorney to appear.
Right.
So it's now 3 months later and you're asking the same thing. The case has been on file for basically a whole year. And so I am concerned.
Okay.
So I'm going to need, if you want me to be doing something for you, vagueness is not,
Okay.
it's not useful for me.
Okay.
This is court.
Okay.
I can't do favors to either of you or the AG's office. If someone wants something from me, they have to truly explain it.
Yes, ma'am. So I got serious
All
concern.
parties in the case.
I got serious concerns about forged documents, as far as a divorce decree and citation of waiver that I did not sign. I was not in the country at the time, and the signature was forged. We were waiting for documentation from immigrations to forward to the court that I was not in the United States at the time of the signature.
Objection, non-specificity. If he could specify which document he was referring to. Judge.
I stated the divorce decree.
The waiver of citation.
Wait,
It's the waiver of citation he's talking about
Oh.
for the divorce decree. It's
Yeah.
the first document in Odyssey.
yes, I was not in the country October 2012, nor the second signature. I was not in the country. So I have documentation
I'm sorry.
that we're pulling up that I was not in the country. Never was in front of Lolita Holiday, never signed those documents. Also, due process was not given when my taxes were taken, nor when my passport was taken.
Objection, Your Honor. He's misstating the law.
I never received documentation when my passport was taken, nor
What does your
when-
passport have to do with? I don't even understand what that has to do. What do you mean
Well-
your passport taken by who?
the Attorney General and child support. That's
Oh,
part of
you're
my
talking
work.
about, okay, this is a separate issue entirely. You're talking about some of the automated remedies they use. They're
Yes.
okay. That is
I
not
have
for
the
me today.
relevance.
I thought passport was related to him being out of the country for this citation. So I didn't understand that it was a totally different issue. Okay, which is why I was confused too, because I'm like, what does the passport have to do with signing a waiver? It could have been your ID, but who is he claiming someone absconded with the passport? I was confused. Okay, yeah, that is an administrative remedy they do. And that is something you'll have to deal with and address through them. It's not before me. And so right now, all that's before me is the motion to confirm arrears.
Well, that's
If I may
And I'm
respond.
just concerned that it's taking this long to get this documentation, sir. Because as I said, I know you've known about this since at least February, if not before.
Well-
Can you explain why it's taking more than 3 months to get the proof you claim you have?
Your Honor,
And why your attorney's not here today when you,
Your Honor, I sent the information into the child support office and they ignored it. So therefore, I'm retaining an attorney after the fact. I sent this in several times, documented that I was not in the country. So therefore, I had to go to immigration and hire several lawyers because it seems like I'm fighting the Attorney General office in Lamarck or something. Because this was adjusted several times. I got modifications to this because the salary that is based on is not, I never made that salary.
Objection, relevance as to a modification. We are not set on a
no,
modification.
he's claiming it was. So, sir, you're claiming it was modified. I think it's relevant. I just don't. I'm looking at the court file. I'm going to overrule the objection about relevance, but sorry, I am questioning. I don't want to waste my time or their time. I don't see any modifications in the court file here in Galveston County. Are you claiming this was modified somewhere else and that some order exists that is not on the AG system or the Galveston County District Clerk's system?
It was modified in Galveston County in Lamarck. She did not show up several times and they adjusted it and it was modified.
Okay. So again, this might help you, but you probably should have gotten a lawyer after the last setting, like you said you were going to. There's the Attorney General's office, and they do a lot of administrative things. Some things go through court and some things don't. They cannot modify child support without it going through the court. And so if you went to their office and discussed modifying, unless it went through the court system, it didn't modify it. And so I'm thinking you might have gone to the office numerous times. But I do not see in the court file that it became a court order. So just so you're aware of that, it has not been modified.
Okay. Well, on behalf of what I stated, went to the the mark office is modified. Therefore, it stated that they would turn this.
Objection hearsay of what
The
was
same,
stated.
sir, the modification, unless you're claiming that there's an order signed by a judge you have that's not in the district clerk's records, that is not, we need another issue. I can't go back in time to modify the order. Sorry, it's either been modified or it hasn't. It's kind of a check the box, yes or no. And as far as I can see, it's a no.
Okay, it was modified in the support given to me, and the statement, the letter sent to my house stated that it was modified. I wasn't a part of it saying going to court. They modified it, sent the letter to me. She did not show up.
Objection,
Sir, I'm not
hearsay.
resetting your case because you think it was modified. Okay, so let's go back to the other issue, which I have concerns about. You claiming that the waiver was
Yes.
fraudulent or whatever you're claiming it is, that concerns me. The
Right.
order modified is not a reason for me to reschedule this case. We're not going back in time to figure out what happened on failed CSRPs. We
Okay.
can't do that.
Judge, I may respond to his claim.
You may.
He claims that, so in court, Judge, Your Honor, we were here October 21st, 2024. Okay, both parties were present. Both parties were present. We did a reset. And it was reset for another court date. Okay. Mr. Tate was then emailed copies of the motion of our petition to confirm arrears, and he was present in court. And then he was given opportunity to reset, to hire an attorney, and then the case got reset. And then he wanted another reset to hire an attorney, and then here we are again. So we were able to close his service path on October 21st, 2024, because he was present. He accepted service on the record. He was emailed a copy of that petition the very same day.
You were emailed a package stating the facts that I stated, as you said my attorney was supposed to send it. So I said, okay.
Why
Your
is your
Honor, I
attorney
have
not
to
here today,
object.
sir? Sir, why is your attorney not here today?
Because it was a mistake with my attorney. Sorry.
Can you call him and get him here today?
She's not available right now till 2:00.
What is your attorney's name?
Christine Thrash.
I'm sorry, you came in and out.
Attorney Thrash. Attorney
You're still
Thrash.
coming in and out, sir.
Attorney Christine Thrash.
Christine Thrash. Okay.
Your Honor, he does not have an attorney. If you look on the Galveston District Clerk website, no attorney has filed a notice of appearance with the court. No attorney has filed a notice of appearance or emailed it to our office. So as we sit here today, Judge, he is not represented. He is attempting to reset the case again, which this court so graciously allowed in February. He's asking for the same thing again. And I'm objecting to the reset. We're already in the middle of a hearing, and I would just like to conclude the hearing and get a final order, because this case has been almost a year at this point, and he has no pleadings on file.
Attorney, I have a right to legal counsel. So you keep trying to bully me on this, and this is my right. Okay. So
Well, sir, we gave you the chance to get an attorney. And by I don't just mean the age is up. The court, when we were set in February, 3 months was given to you to hire a lawyer. And so while it is your right to have a lawyer, it's not your right to indefinitely postpone the case to get that lawyer. And that's where my concern is coming from. This case, I want fairness, and I am concerned if you had that fraudulently done, but why your attorney, who's a good attorney, wouldn't have filed something on your behalf or something to let the AG's office know that they're there is a little confusing. These allegations are big. Why you wouldn't have, let me just say, to overturn, even if you prove to me today that this is fraudulent, it still does not overturn your divorce decree. It's an extreme remedy that you're asking for, because your divorce decree is from 2013, so over 10 years old.
yeah,
So knowing,
Oh, no, you signed the citation when you were home to visit. Yes, you did. So don't even play games, Mallory. I don't have time for your games.
ma'am, please don't speak to him, and please don't speak that rude. I do want to hear your side. It would be very helpful, but speaking to him and being rude does not help the hearing. It makes things escalate. So please don't do that.
My apologies.
Okay, but if you'd like to respond with something that would be helpful, I would appreciate it. Is there anything you'd like to say, Ms. Ricard, in regard to this issue?
Yes, when he was home in 2012, he signed that citation. in front of several people, and he knows this. And I don't know why he's saying he's not aware of his divorce decree. Before it was filed with the court, I have several emails where he was in agreement of it. So these games that Mallory Tate is trying to play, they have, like you said, this has been going on from 2012, and here we are in 2025. The only reason he's disputing these rears is because he was unable to obtain his passport. If you look at the payment of the record, it'll show he didn't make consistent payments until he actually received a job on the table because he was getting paid cash and his money could not be traced. He hasn't filed income tax. I mean, it's just it's various layers to this. And I don't know why he's refuting that he doesn't owe. Like I said, he didn't start paying consistently for the rears until 2021 after the kids graduated from high school. Like I said, so I mean, I have evidence. I'm not about to go back and forth with the court today about a divorce decree because that's not what we're here for. We're here for the rears. You did not support your kids. When you were ordered to pay child support, you had time to do modifications. When you had the opportunity, you claimed you did them. If you did them, the court would have copies of them. If it's not documented, it didn't happen.
Judge, and may I add to that? Furthermore, we are not here to get he's out of time for de novo, motion for a new trial. This was in 2013. The divorce decree was signed by the court at the time. We are here on a confirmation of arrears. There are no pleadings on file. We just need to get a confirmation of arrears done, a payout to get these high arrears paid off. He has no pleadings on file, no evidence of anything presented to the court in writing or anything to the Attorney General's office. He does not have an attorney representing him. He's been given several opportunities to do that, and we just asked the court to confirm the arrears and set a fair payout to begin June 1, 2025. Thank you, Your Honor.
Your Honor,
You may briefly speak, sir.
Your Honor, the salary that was on the divorce decree is impossible. I never made that when I came back to the United States.
Objection relevance as to what child support was ordered back in 2012. We are here for a confirmation of arrears, Your Honor, not a de novo, not a motion for a new trial to overturn that divorce decree from 2013 in any way. So I have to object relevance.
Sir, she has to interrupt. Remember I said don't interrupt unless you have a legal objection. That was a legal objection.
She's interrupting me. I was stating a fact.
Sir,
I never
she
made
made a legal objection.
Money.
Sir, I'm going to sustain, sir, please listen to me. Remember I said in the beginning, no interruptions unless it's a legal objection. That was a legal objection, and I'm sustaining her legal objection. I can't go back in time to redo child support that ended a few years ago. And so I'm sustaining her legal objection. Is there anything additional you'd like to say about a different issue?
Your Honor, that's why I asked for legal representation. She's on a legal objection. I'm not a lawyer. So she's objecting to what I'm trying to make a statement stating that I did not make the salary that was.
Objection relevance again.
Sustained. Okay. I'm going to find that I'm not resetting this case. I am going to confirm arrears. I'm finding that
and
Mr. Tate has had since October to hire counsel. And he's also had since October, really since before then, to file any possible legal pleading such as a bill of review regarding this case and has not. I'm also finding based on the pay record admitted that he has made payments on this child support and knew about it in 2013, payments in 2014, payments were made in 2015, 2016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, and 2024, and now 2025. So I believe he's been aware of this obligation for quite some time, and the time frame to file a bill of review has generally passed. That being said, even if he didn't realize it until this action was filed, he's had time to file it since then as well, and it has not been done. So I am confirming the child support arrears and rendering judgment. I am ordering a child support judgment against Mr. Tate in the amount of $95,713.34. as of April 30th, 2025. And I'm ordering that he pay that judgment back at a rate of $1,500 per month. Sir, can you please come back? I am also ordering a medical support judgment of $125 per month. I'm sorry, the medical support judgment is $17,956.96 as of April 30th, 2025. I'm ordering that Mr. Tate pay that back at a rate of $125 per month as of June 1st, 2025. The payments all begin June 1st, 2025. And I'm ordering that he pay court costs to Galveston County on or before May 5th of 2026. Mr. Tate, can you please turn on your camera so I know you're still there? I'm going to remind you, I've said this at the beginning, and it's also in my waiting room, my virtual waiting room. You do have a right to a de novo hearing before the referring court regarding any matters. If you wish to do that, I recommend you speak to Ms. Thrash as soon as possible, and she can file any necessary paperwork. But that is my ruling today, and the state is going to draft an order based on my ruling, and they'll be sending it to you through DocuSign to review and sign off on. If you don't sign off on it, they will be just submitting it to me based on my ruling, and I'll review and make sure it matches the ruling, and then I will sign off on it. And so
Thank you.
have you all go back to the breakout rooms where you'll get a chance to review the order. But thank you both for coming in.